Hello and welcome. My name is Joseph Partida, and this is my research case study presentation. I wanted to start off with our first case analysis, and it's going to be the New York Times versus Sullivan in U.S. Supreme Court. Sullivan plays the role as a respondent, an official from Montgomery, and New York Times is the petitioner. Sullivan brought suit in a state court alleging that he had been libeled by an advertisement in corporate petitioner's newspaper, the text of which appeared over the names of the 4 individual petitioners and many others. The advertisement included statements, some of which were false, about police action allegedly directed against students who participated in a civil rights demonstration and against the leader of the civil rights movement. The respondent claimed the statements referred to him because his duties included supervision of the police department. The respondent's complaint alleged that he had been libeled by statements in a full-page advertisement that was carried in the New York Times on March 29, 1960, entitled "Heed Their Rising Voices." The advertisement began by stating that, as the whole world knows by now, thousands of Southern Negro students are engaged in widespread nonviolent demonstrations and positive affirmations of the right to live in human dignity as guaranteed by the U.S. Constitution and the Bill of Rights. The elements of defamation include libel, which defines that the action was published and seen by more than one person, and slander is a spoken form of defamation, and it is harder to prove than libel. Public officials and public figures have to prove that defamatory statements were made with actual malice in most cases. So the Supreme Court holds such a proposition, and it may not constitutionally be utilized to establish that an otherwise impersonal attack on governmental operations was liable of an official responsible for those operations. Since it was relied on exclusively here, and there was no other evidence to connect the statements with respondent, the evidence was constitutionally insufficient to support a finding that the statements referred to respondent. So the final judgment of the Supreme Court of Alabama is reversed and the case is remanded to that court for further proceedings, not inconsistent with this opinion. And we're going on to our next case analysis, part 2, which is going to be Gertz versus Welch. The respondent, Robert Welch, publishes American Opinion, a monthly outlet for the views of the John Birch Society, and the petitioner is Robert Gertz, an attorney for Elmer Gertz is an attorney in which the victim's family has retained as the petitioner. The respondent, Robert Welch, publishes American Opinion, a monthly outlet for the views of the John Birch Society. The petitioner is not a public figure. The managing editor of American Opinion commissioned an article on the murder trial of Officer Nucio. For this purpose, he engaged a regular contributor to the magazine. In March 1969, respondent published the resulting article under the title "Frame Up: Nucio and the War on Police." The article purports to demonstrate that the testimony against Nucio at his criminal trial was false and that his prosecution was part of the communist campaign against the police. The district court denied respondent's motion for summary judgment in a memorandum opinion of September 16, 1970. The court did not dispute the respondent's claim to the protection of the New York Times standard. Rather, it concluded that petitioner might overcome the constitutional privilege by making the factual showing sufficient to prove publication of defamatory falsehood and reckless disregard of the truth. So in the case, it states that there was also no basis for the charge that petitioner was a Leninist or a communist fronter, and he had never been a member of the Marxist League for Industrial Democracy or the Intercollegiate Socialist Society. Having these types of allegations can constrict a person's business and put a public bias from outside perspectives. What I would have done as a respondent to avoid the whole situation would be to publish an opinionated column that was protected under the First Amendment in which no defamatory actions could take place. And for our state defamation law in California, here are the elements of defamation. I'm going to start off with defamation per se. A plaintiff need not show special damages, such as damages to the plaintiff's property, business, trade, profession, or occupation, including expenditures that resulted from the defamation, if the statement is defamation per se. And as for public officials in California, public officials are those who have had or appear to have had substantial responsibility to control over the conduct of government affairs. And for public figures in California, to classify a person as a public figure, the person must have achieved such persuasive fame or notoriety that he or she becomes a public figure for all purposes and in all contexts. Someone who voluntarily seeks to influence resolution of public issues may also be considered a public figure in California. And as for limited purpose public figures, a limited purpose public figure is a person who voluntarily injects themselves or is drawn into a particular public controversy. And for actual malice and negligence in California, a private figure plaintiff bringing a defamation lawsuit must prove that the defendant was at least negligent with respect to the truth or falsity of the allegedly defamatory statement. Public officials, all-purpose public figures, and limited-purpose public figures must prove that the defendant acted with actual malice, knowing that the statements were false or recklessly disregarding their falsity. And California courts recognize a number of privileges and offenses in the context of defamation actions, including the fair report privilege, the opinion and fair comment privileges, and substantial truth. And as for the statute of limitations for defamation, in California, the California statute of limitations for defamation is 1 year. And California applies the single publications rule pursuant to California Civil Code 3425.1 and 3425.5. A California court appeals recognize the single publications rule in the context of publications on the internet. I can relate to this case by using it as an example on how things can go wrong in the communications industry. When it comes to publishing and having the power to persuade the masses, it comes with big responsibility. And once you publish something, then it will never go away, especially in the digital era that we live in. So when it comes to publication and being smart with your words, I think a strong understanding of the First Amendment and also a strong understanding of what went on in this case will prevent me from experiencing the pain of a defamation lawsuit in my future career in the communications industry. And I thank you so much for listening, and this is going to be the end of my presentation. Thank you.